Good morning, everyone. Thanks for being here. I'd like to call this meeting to order. This is the House Appropriations Subcommittee on Corrections and Judiciary. So welcome. The purpose of this meeting is to hear from SCAO, and really the thing that we'd ask is for some specific highlighting of the funds that are appropriated to SCAO, which is a line item of about $14.5 million, and specifically what's also in the Supreme Court line item that is at $16.5 million. And so we'll have a chance to hear from Tom Boyd, who's from the State Court Administrative Office, give us an update on that. And Mr. Boyd, if you are ready, come on up. Oh, and while you're doing that, I'm just gonna take roll, okay? So settle in.
Chair Slaw.
Here.
Representatives Markkinen.
Here.
Beeson.
Here.
Cavett.
Here.
O'Neill.
President.
Mr. Chair, you have 5 members present. There's a quorum.
Thank you.
Minutes.
And then let's quick do the minutes from our last meeting. Representative Cavett will make a motion that we approve the minutes from our subcommittee meeting, and no objections, the minutes are approved. Mr. Boyd, preliminaries are over. We're up, we're up to you.
Thank you, Mr. Chairman, members of the committee. Representative Fink, good to see you. Ms. Edwards, Ms. Paul, good to see you. I told the chairman before the hearing that I love an opportunity to brag about the good work being done at the State Court Administrative Office and the Supreme Court. I'm going to try and do some introductory things, but then I understand you have questions. So I want to be respectful of that, and rather than plow through a long story about what each of the areas within the SAO are doing, and I'm going to pause for an opportunity to ask questions, because I think that's really what you want to do. I want to start by saying that the judicial branch has been really grateful by the tremendous support of the legislative branch. We are really grateful about the tremendous support of the legislative branch over the last decade, certainly over the last 5 years since I joined the administrative office as the administrator. It's been a great partnership, and I think we've solved common problems together, and we're grateful. I'd like to start, there's 2 handouts that Ms. Risco circulated. The first is actually selections from her presentation to the committee earlier this year. I got to admit, I didn't see the presentation, but when we reviewed these documents, I was not surprised that Ms. Risco did an excellent job presenting on who we are and what we do. I've been requested by Representative Leitner to make a presentation on SCAO later in the year. I just think Ms. Risco could probably do it based on the presentation that she made to you all. But these are just select slides of a much longer presentation, and I just want to start with the second page, where it's talking about the shift in the Constitution of '63 to declare that Michigan has one court of justice. It isn't a unique concept. It isn't unique to Michigan. It isn't unique to constitutions written in that period of time, late 50s, early 60s. This one court of justice under the Supreme Court concept is in a variety of state constitutions, and it's certainly in ours. At the risk of being a little confusing, I want to jump then to the blue packet, which is presentation from us today, and talk about 2 other constitutional provisions that are on the second and third page of that handout. The first is Article 6, Section 3. So we started in Section 1, where the Constitution declares us one court of justice under the leadership of the Supreme Court. Well, in Section 3, it declares that the Supreme Court shall appoint a chief, and that chief's powers are limited only by the rules, which are governed by the court itself. So this is not the way every state is structured. Some states have chief justice elected as an individual job. Some have chiefs chosen by the governor. Some have chiefs that serve long terms. Michigan has a chief chosen by its membership. And there's sort of an informal understanding that would be for a 2-year term, and that a chief would serve 2 2-year terms. My point in telling you all this is that leadership changes. And under the rules, the organization might change too, because we respond to the will of the chief. Later in the same section, it says that the Supreme Court shall appoint an administrator of the courts. That's me. So the Constitution created a job, administrator of the courts. In Michigan, we call that the State Court Administrative Office. The Constitution doesn't, but we do. And we call the job the State Court Administrator because the Constitution says you can have an administrator. So I serve at the pleasure of the court, but I respond directly to the Chief Justice because she is the individual justice who's been empowered by her colleagues for the administrative responsibilities. I always assume that anything she asks me to do, she's got 4 votes for. It hasn't let me down in the 5 years I've been doing this, but that's totally up to her. I have no idea the inner workings of what happens on the 6th floor. I do what I'm told, and that's by a majority of the court. The communication to me is through the chief. That's my boss, as it were, although it's clear that the court is my boss pursuant to the Constitution. It also says that the court can hire other assistants to the Supreme Court as may be necessary to aid in the administration of the courts of this state. Almost everything we're going to talk about today is that subordinate clause, other assistants. The money that we're talking about today in the SCAO line and the Michigan Supreme Court Administration line, it's almost all human resources, and it's spent on the people that are hired because of that sentence. So the last thing I want to mention about the Constitution is in Section 7 of Article 6, which is the third page in the blue handout. And the Constitution gives the Supreme Court general supervision of its staff. I've already explained that. 4 of them want to fire me. I'm out of work that day. I'm pretty sure that was one of the things Representative Fink was thinking when he was running last fall. I'm not really sure. This is, and that's true for all of us. We're all at-will employees. We're in the judicial branch, not the executive branch. We're not involved with civil service. We don't have unions in the general budget for the judicial branch. So that sentence says, we're at-will employees. Section 7 says the Supreme Court shall control the preparation of its budget recommendation and the expenditures of monies appropriated for any purpose pertaining to the operation of the court or performance of the activities of its staff. Again, I think we're going to talk about a variety of lines, but I know, as the chair just reiterated, we're talking about 2 lines in particular, SCAO and MSC, and those lines are right there. The Supreme Court, through the chief, is responsible for how this gets laid out. If we go back to Ms. Risco's handout, the white handout, she very accurately describes sort of the 6 buckets. She describes them as spending areas, but I'm going to call them buckets of money appropriated to us and what we do with them. The next page, which is ironically numbered 16 in a 4-page document, is the breakdown from the current fiscal year. That's how the money falls into the buckets that are described on the previous page. Some of what I say today will kind of touch on other buckets, but almost exclusively we're in the green wedge, the 24% of the budget, which includes, among other things, the SCAO and the MSC lines that you're asking about. But in general, they're just appropriations to serve under Article 6, Section 7, the administration of the courts. So if we turn to the last page of the blue handout, this is the current organizational structure of the Michigan Supreme Court, right? I don't say the Michigan Supreme Court and the State Court Administrative Office, because that conjunctive "and" in an English sentence would imply that it's something different, and it's just not. The Michigan Supreme Court is in charge of all of this. Everything I'm going to talk about today, they're in charge of. And so the fact that they, in their wisdom, and the chief, in her wisdom, have divided it according to this chart is only because that's the way they've divided it. In terms of the law and the constitutional provisions I've just described, and the appropriating authority, the spending authority under Article 6, Section 7, it's really just one organization. So having said that, I would like to reframe the conversation a little bit by talking about 2019. In 2019, this organizational chart looked very different than it does today. So there was the court offices, which is the column on the left. There was the general counsel's office. And to the right of that, there were 3 separate lines. Between December 2019 and April 2022, in addition to having a global pandemic, we had 3 retirements. Ed Zobak retired last. Milt Mack, the state court administrator, my predecessor, retired in March. He actually didn't retire. He became emeritus. He's still emeritus. He serves us as a volunteer today. Wonderful, wonderful favor to the state of Michigan that he does to us every day. And a woman named Dawn Monk. Ironically, I just saw Dawn Monk at former Chief Justice Michael Kavanaugh's funeral last week. Haven't seen her in a long time. And I said to her, we have whole committees set up to do the things she used to do in her brain. So those 3 very senior people all walked out the door within those 4 months, the end of 2019, the beginning of 2020. So what you see here looks hardly anything like what you would have seen in 2019. Why is that relevant to our conversation today? Because the Chief Justice, in this case, Bridget McCormick, laid this org chart out, in a way that served the organization pursuant to her constitutional powers, but it doesn't necessarily reflect the individual lines the way that you see them. So I'll use it as an example, and then I'll go through the divisions. In our Field Services Division, which is the second box there on the left, there are monies in that division that come from the state court administrative line, but there are also monies in that division that come from foster care review board, community dispute resolution, problem-solving courts, jail reform advisory support, justice for all. So there's a variety of programs that the legislature has historically supported, and specifically supported in the current fiscal year budget, that we implement in that area. So it's not just an SAO line. So we've received some questions, and I guess I should note that I think one of the reasons we've been asked to answer the questions is because we have been maybe struggling to answer some of these questions in one-on-one conversations. So I really appreciate the opportunity to clarify. And as I've indicated to Chair Slaw before the meeting, if there are specific questions, a dollar amount here or there, we're going to get those answered for you. I don't necessarily know those questions yet today. Oh boy, I forgot one real important thing, Mr. Chairman, I apologize. I want to introduce my colleagues who are with me. Deputy General Counsel Trevor Van Dyke. Mr. Van Dyke, in addition to being Deputy General Counsel to the Michigan Supreme Court, has long experience within executive and judicial branches, liaisoning to the legislature. He's our primary contact. You know that. He's here all the time. Anything you need, you call Trevor. He's joined by the Supreme Court's Budget Officer, Casey Harold. Casey's here because he's going to write down your questions, and we're going to get you answers because it'll be, I think, at a level of detail that I'm not going to be able to get. Okay, so using the Field Services Division as an example, the work that's done in the Field Services Division certainly includes things like the problem-solving courts, but it also includes a variety of different groupings of job position description we call court analysts. And the court analysts are responsible for a multitude of things, including implementation of legislative changes. So when there's a new public act creating a substantive change in the way that courts behave or the way that money flows or any number of things that the legislature changes the way that the judiciary responds to substantive law, those colleagues of ours in field services under the court analyst subdivision are the people who understand, analyze, and make recommendations about how we should help the courts comply with the law. We spend, as you can imagine, a lot of time trying to understand the law and comply with it. That's one of our major things that we do, and we assist the trial courts in that. In the Judicial Information Services, JIS line, box there that's 2 down from Field Services, those people do the same thing, working in connection with the Field Services Division to make sure that our computer system complies with the law. Great example from the last 3 months. In the last session, the legislature enacted the law to allow a ticket with a school bus stop arm camera. Understand the policy goal. It's the financing that affects us. The policy goal doesn't affect us at all. Someone writes a ticket, they submit it to court, we handle the ticket. It's what we do all day, every day, literally hundreds of thousands of times a year. However, on the back end, once the ticket's paid, the law said that the money goes to a school district. Well, our computers don't do that. Our computers transfer the money to the funding unit, or in rare exceptions, 9, I think, they have their own checkbook and they distribute the money pursuant to statute. But most courts send the money to the treasurer, whether that's a county treasurer, a city treasurer, or a township treasurer, and the treasurer then distributes all the money. So what we needed to do is to first, in field services, understand the change in the law, and then in JIS, enable our computers to communicate effectively with the treasurer about who gets the money, right? Our computers say there's a $45 state minimum charge in a criminal conviction. We send that over to the treasurer. The treasurer knows how much of that goes to the Department of Treasury, how much of it stays with the local jurisdiction, county, city, or township, and they apply the formulas. Well, this is outside of that. This is not only a new distribution, but a distribution to someone whom we've never sent money to before. So we have to figure out a way to get the computers to communicate with the treasurer that this goes to not a school district, but which school district, right? In a perfect world, we would have just used the 5-digit school code that the Department of Treasury uses. We did not happen to have a spare 5-digit field. We had a spare 4-digit field. So the point is that these areas have to work together to implement the will of the legislature in a way that gets the job done. And often, as in this case, with a very short period of time to do it. So that's an example of how these groups within our office work together to facilitate the will of the legislature. All right, let's take a different example about specifically in response to the question of what's the difference between an SCAO expenditure and an MSC expenditure. So you look in the org chart under the State Court Administrative Office, you see finance, human resources, right? Well, let's talk about human resources. Human resources is not human resources for the State Court Administrative Office. It's human resources for everything you see here, plus the Court of Appeals, and to a lesser extent, the State Appellate Defender's Office, and they do some work with the Judicial Tenure Commission. So that box on the org chart that falls under the State Court Administrative Office really has a much broader purpose. It isn't just we use the money from this line to do that. The point would be money from a variety of lines, functions from a variety of lines are served by that one functionality. So that's another example of how it's pretty tough to determine what's going to happen next. The questions we've asked are, how do you budget going forward? Well, we understand what needs to be done, but we move people around as the organization needs, not necessarily as the lines are laid out. A good example of that is just within the last, I want to say 12 months, I don't know exactly, the Public Information Office moved from an independent box at the same level as General Counsel and State Court Administrator to under General Counsel. Now, that was just an internal decision made by a Chief Justice of the Supreme Court, in this case, Chief Justice Beth Clement. So that met her vision of the organization and the services she believed were important to provide the support under Constitution Article 3. Article 6, Section 3, excuse me. And so that change was made, but we don't sort of change how we pay for it, right? And so tomorrow, the new Chief Justice, Megan Kavanaugh, may move a box and it won't change how we paid for it. So I think the question, where does the money from this line go and where does the money from that line go, is best answered retrospectively. So if it meets the committee's needs, we can certainly tell you in the fiscal year 24 where we spend every dime for those two lines. We can tell you in the first 2 quarters of this fiscal year where we spent the money from those 2 lines. So if that meets the needs of the committee, that's really no problem. But talking about what happens tomorrow is harder because I don't know if the Chief Justice is going to move boxes or reorganize in a way that would make the question, that would render our answer to the question wrong, because it's really hypothetical at this point what we'll do. We have some idea, of course, and we're proceeding on a path, but what I have to offer is what we did in the first 6 months of this session, what we did last year, and I hope that informs what you're trying to figure out. Mr. Chairman, I'd be happy to pause for a question. Like I said, I think you have more questions for me than you want me to just ramble on about the good work of the office.
So are there questions that we have from
Thank you, Chair. And Tom, the budget here for the indigent defense, I'm sitting on a different chair. And once again, are there any of these funds in the Supreme Court budget that are expanded to services for individuals that are not United States citizens? And I mean, for example, like the funding, as I said, then they said yes, in my funding for legal services such as court-appointed attorneys. And if there is, can you explain where it is in your rulemaking that budget is acceptable? Because I want to know why we are funding them when they sat in my committee and said that.
I apologize, Representative, I wasn't in the committee, so I'm going to try and answer the question. I think I understand the question.
The Indigent Defense Chair,
The
Commission Chair, said that they do fund people from the non-U.S. citizens. So I want to know why.
Okay, so the Michigan Indigent Defense Commission is not in the judicial branch. And this money is not going to the Michigan Indigent Defense Commission.
So
So
the public defenders kind of come through that, right?
not this line, no, sir.
Okay.
As a matter of background, I was appointed by Governor Snyder to the group that created the Indigent Defense Commission, and I was among the inaugural appointees of Governor Snyder to the Indigent Defense Commission. It's something I know more about than the average bear. This money does not end up there. That's all in the LARA budget. There's no money in our budget that ends up in the Indigent Defense Commission. This money mostly goes to the State Appellate Defender Commission, which is in our budget, but I don't supervise. They're independent, a type 1 agency within the judicial branch, and I would have to respectfully either get the answers for you or defer the questions to their leadership.
And so the appellate court, right, doesn't defend citizens from not from the United States?
I have no idea, sir.
Okay, thank you.
In the budget.
There's a line item for the development of the e-filing system, the MyFile system. That line is, if you look at Ms. Risco's pie chart, in the blue box in the top right, trial court operations, one of the lines in that part of that bucket is called the Judicial Electronic Filing Fund, and that money comes currently from and Casey's right here going to catch me if I say something wrong, but that money comes currently from a filing fee paid by filers and is put in that fund and expended solely for the purpose of creation, implementation, and training on the MyFile, the electronic filing program.
May I have a follow-up question? Are you familiar with the federal e-filing system, PACER?
I know what PACER is, yes, sir.
Yeah.
I'm not intimately familiar with it. I was 30 years in state government, 10 as an assistant attorney general. I was in federal court once, and then 14 years as a member of the district bench. So I've never
Fair enough.
practiced.
Yeah.
People in this room probably spend a lot more time in federal
I
court
just
than
was
I.
curious if you think it would make it easier on our small and more rural courts, the PACER system, but.
I'm not an expert, sir, and my understanding is the PACER system is about to be outdated. The problem with technology, as you know, from everything from our iPhones to our laptops, technology changes very quickly. And so one of the nice things about the JIS system, and again, I cannot thank the legislature enough for your joint work with us to make JIS the statewide unified case management system, is that it modernizes every day. We have it's a longer story, and I won't belabor the point. I heard Mr. Chair saying we want to move on to financing, but we use an agile software development approach. So we are literally improving that system every single day and expanding it as pursuant to the support of the legislature from a few years back.
Thank you. Could I go a different direction real quick? Thank you, Mr. Chair. Thank you for that answer. Can you explain any significant changes in policy now that we have a new Chief Justice?
I would say, in fact, that I'm not only not aware of any significant changes in policy, that I believe that we're remaining very consistent on several points of policy. As an example, the conversion of the Oakland County Circuit Court to the JIS system is one of our top priorities. Oakland County's homegrown case management system is about to become obsolete. There was actually a fear about a year ago that it would, in fact, crash. Oakland County has a tremendous IT department, and they have stepped in and they've given us what they believe to be about as much as 5 more years. But the point is that it's becoming obsolete. Same phenomenon I just discussed. And so that's one of our main priorities. The first thing that Chief Justice Kavanaugh did was send a letter to the chief judge, the county clerk, the county executive, and the chair of the county board saying, we are not changing a thing, full speed ahead. Thanks for your support, let's get this done. One of the next things she did is call the county executive to make sure he got the letter and say, full speed ahead, we're getting this done. So the strategic agenda for the judicial branch is currently in the hands of a group named the Michigan Judicial Council, created in 2021 by the Supreme Court. It was chaired by Chief Justice McCormick. The other member of the court that was on the Judicial Council was Justice Clement. When Justice Clement became chair, the other member on the council became Justice Kavanaugh. The two top priorities for the Judicial Council in its first strategic agenda are that statewide unified case management system and the work that we're doing pursuant to Public Act 47 of 2024 to look at alternative funding methods for the trial courts. So as she moved from the second member of the court to the chair, she's continuing on the path, the strategic path set out by that group.
All right. Thank you, Mr. Boyd. Thank you, Chair.
Sorry.
No, oh yeah, there we go. So, just a question, as I listened to how you presented it, Tom, what it sounds like to me, so this is what I heard, right? Not maybe what you said, but what I heard, is that the courts, the judicial side, we should just ask you what you want, total dollars, and write one line item, which is the total amount of what your ask would be for all of the services and everything that you guys provide, and not have any other budgetary kind of thought process. That's how it feels like you're communicating it to me. That may not be what you said, but that's how I feel. Is that really the thought process? I mean, that the legislature should just say it's whatever the total was. I don't have it in front of me right at the moment, but the total for the entire judiciary, just it's one line item, and the judiciary can choose where it's going to be spent and how much and where, and we shouldn't worry about it. Is that?
Well, first,
Is that what you said?
it is not what I said, but
Okay.
but I understand the question, and I respect the question a great deal. And what I would like to say first is I apologize if that was the impression you took, and I'd like to go back. We'll rewind the tape. I'm a huge fan of the Women's Softball College World Series, and so I'm watching rewinds all the time right now. So I'm going to rewind the tape in the hearing here and say that I've specifically discussed two projects that we couldn't have done without you, that it's only in partnership that we did. And it's in thanking you for that partnership that I began my conversation today. Those two examples I gave were the MyFile system and the expansion of a statewide unified case management system. Those were specific conversations with Republican legislators who chaired these committees in the relevant dates when those things happened. One was 22, I think, and the other 21, and the other one was a long time ago, a decade ago. And those are conversations between the judicial branch and the legislative branch saying, we would like to effectuate our responsibility by doing X. However, in order to do that, we need your help, because within your responsibility is the purse string. And so we would like to work with you on those things and have had tremendous success. It's only through those partnerships that we are really modernizing the trial court system and the support paid for the trial court system. I could give you many other examples. One of the recommendations from the Judicial Council is the modernization of court technology. And the JIS system, which again modernizes every day, we were charging a fee for, and many courts couldn't afford it. And with the support of the legislature through this committee, we eliminated the JIS user fee paid by locals, and the general fund stepped in and covers that fee. So now the JIS system is provided without cost to the locals. So it's only through the support of the legislative branch that we can have that conversation, express a desire that the legislature effectuating your responsibility has met successfully over at least a decade that I've been paying attention, maybe more, I'm certain more. And it's that partnership that moves us forward. So I will tell you, real specific to your question, we did last year, 2 years ago, I don't remember, say, hey, can we merge the problem-solving court lines? Because it would be more intellectually honest to say the total you give us in problem-solving courts, which is just short of $20 million, some of which is restricted fund passing through like Office of Highway Safety Planning at the state police. But it's a total of about $20 million. Because we really try to use that to maximize good. An example, mental health courts, for a variety of reasons, spend a lower percentage of the appropriations every year their utilization rate is lower than the other programs. Utilization rates means we give them $100 and they use $100, or they use $99 or $98, and that 98 is their utilization rate, 98%. The utilization rate in mental health courts is lower for a variety of reasons that I could go into, but probably you don't need to hear right now. Therefore, there's money in mental health courts that we might be able to move over and serve veterans. So we say to this committee, I'm not sure any of the current members were on the committee, but we say, could we just collapse those lines and it would give us flexibility? And the answer, in private conversations with the chairs, Ms. Risco, other staff were there, said, you kind of have flexibility anyways, just do what you need to do, but we want to keep those lines because we want to have the conversation about those lines. And we say, okay, so that's where we are. We still have all those lines. But in reality, we share the common goal of enhancing public safety through rehabilitation, through problem-solving courts. And how do we actually effectuate that? We work on together, and it's an ongoing dialogue. So I can give you more examples of things we couldn't do without your partnership. And as a result, we talk about lines. But what I'm saying is these two lines really support the organization. And so when I look at HR, we could tell you that money comes from this line or that line, but it's not an accurate description of what they do, right? HR cuts my paycheck, but they also cut my paycheck when I was a district court judge. If you look at the Ms. Risco's pie chart, that big blue box on the bottom left, that's money we pay to judges and justices. So in the top right blue box, trial court operations, there's a whole bunch of money that we just pass through because of the appropriations scheme, because of the legislative scheme, the statutory scheme. You give us the money to send to counties through court equity, through drunk driving reimbursement, through a variety of programs. So there's a whole bunch of things here we do really very closely with the legislative branch. There's restricted funds that we use. So the MyFile Fund is a good example. The legislature created a restricted fund to be used for a restricted purpose, and we use it exclusively for that purpose. So again, I apologize if I created the impression that I was saying, hey, just write us a check and we'll do good with it. Not my point at all. It's only through this complicated, consistent partnership with the legislative and executive branches that we've really been able to modernize what the court system does. And I could.
Thank you, Robin. So as we're regularly having this conversation within the legislature right now about transparency and being really open and having people understand where the dollars are going and how it flows. And that, as I read through those two line items, that's the thing that seems to be missing to me, is that we've got, across the two line items, we got $30 million, and it's like, it's administration. Well, I'm sorry, that just sticks a little bit as it comes in, right? So with that, are you thinking that we should just that we don't unroll those line items and give people information? Is that what you're asking me to do, or is that not really what you're asking? And I just need to understand something differently than what I'm hearing. Can we be transparent? Can we actually
of course.
break it out?
Yeah. Well,
and maybe it's historic, like you mentioned earlier, a couple minutes ago when you were starting to answer my question, is that you can go backward.
Yep.
And give us what have we spent it on?
Yep.
So how much and where? That would be hugely helpful to me, because then I could say, okay, well, here's what it was. Here's what I think we really need based on what you're asking for. How do I fill those buckets so that I understand that you're not required to spend it in that way. I get it, because you're the judiciary branch is different from us, and so you've got the ability, as the Constitution allows, to spend it as you desire. But it seems like we should be more willing to have it be open to our public, where it's coming from.
Sure, absolutely, Representative, Mr. Chairman, and again, we have zero problem with that. I just can't do it for tomorrow. I can do it for yesterday. And I want to focus on part of the question. It's not administration. We didn't name that line that. So within the Supreme Court line, we have clerks, commissioners, a whole bunch of people who just are lawyers that help the court do its work and render decisions. I wouldn't call them administration at all, but we might pay them out of a line that's called administration because that's what the line's called. It's really operations might be a better word for that, for those lines. But again, we don't quibble about that. We just get the work done. And yeah, we can tell you the easiest way for us is to tell you within Sigma, which is DTMB's payment system. You're familiar with Sigma. Within Sigma, they have spending units. And so we can look at the spending unit, and it might say commissioner. It might say, I think they probably call my office SCAO executive leadership or something like that. And we can tell you how much money we spend in FY24 in every one of those units. Our answer is definitely not, you can't see or the public can't know. Absolutely not. Our answer, and one of the reasons I think we've had a hard time answering this question, is it's hard to say what's going to happen tomorrow. What happened yesterday? No problem. Absolutely.
And with that. Thanks, Nick. God, I'm glad you guys are next to me to help me out with this. I guess that's the thing for me is I'd love to be able to work on what did we do, where is it, what happened in 2024, right? So that gives us a base, and then where we want to go, so that I know where and what we're intending to spend it on, because I think the people of the state deserve to know that. So I'd love to have us work toward that as we continue to try and move the budget along, because I think it's valuable.
Mr. Chairman, I apologize, just one last thing on the question of transparency. One of the goals of the current majority in the Supreme Court is not only transparency, but we use the word radical transparency. We have dashboards online that describe case flow management in every single trial court. We have dashboards online and coming online that describe how cases are handled and disposed of. So the idea that we're not for transparency, I want to reject, because we are moving towards more transparent future. One of the values of a statewide unified case management system that we convinced your predecessors in this chamber is for more accurate information. We are partnering with Accenture to build a new data analytics platform called a data lakehouse, which will be able to aggregate our data and combined with data from executive branch agencies like MSP and Corrections, Secretary of State, Department of Health and Human Services, to provide an unprecedented picture of the people who come before the court. So our goal is transparency writ large, and with the support of this legislature and your predecessors, we've been successful in our early steps.
Good. One of the things that I know that we internally, so I've sat on the corrections budget and now the judiciary budget for a number, now judiciary just this year, but corrections before this. And we have the ability to go in and see stuff in Sigma for corrections, so we can actually see some of the stuff. So it truly is maybe more transparent to us because we get a chance to see it. My understanding is we don't have that kind of access to anything that you guys are doing on Sigma. And I'd be happy to pull that back if that's not true, but I think that's what I heard. Anyway, so maybe that's part of it is because we're not able to see it, it breeds more questions than it does answers. So just as part of the whole thought process as we move forward. Now, are there any other questions? Yes, Mr. Reese.
Thanks, Chair. Tom, so, and looking over the budget, because we have to review that quite often, last year there was boilerplate language in regard to the prescription compliance to oral fluid testing, which was $500,000 to continue the mental health for veterans, which we have a big, and drug courts. How much money was used? Like, that's what we're talking about. Like, how much money was used? And it looks like there was a couple $100,000 taken out for a separate project. Let's see where it's gone and show us so that we want to continue to do this.
Sure. Thanks for your question, Representative. None of that money's been used at all.
Okay.
There's $500,000. It's a multi-year work project created in last year's budget, and zero of that money has been spent. I'd be happy to talk more about the project, but the specific answer to your question is none of that money's been spent.
Awesome. Thank you.
I'd love to have you talk about that just for a minute.
Sure. The boilerplate, it's in the I believe the fourth year of the boilerplate, and it talks about continuing the prescription compliance oral fluid testing program. So in the first 3 years of that test, and we've submitted reports to the legislature the following March after each year. We have demonstrated through that test that you can in fact use an oral fluid swab to determine if someone is taking a specific medication. And we've pretty much, in our view, proved that conclusively, and I don't think anybody disagrees. The question is, can we, continuing on the same path we're on, do all of the things that you've asked us to do in Section 404 of our budget? Section 404 asks us to do other things other than simply say, will an oral swab detect the presence of a prescription drug? You've asked us in that language to determine compliance with requirements set by a treatment court. Well, under the test for the first 3 years, we can't do that. The order from a treatment court judge, I presided over a mental health court judge for, 8 or 9 years, a mental health court for 8 or 9 years. The order is almost always comply, follow doctor's advice, doctor's instructions, and take medications as prescribed. We have also proven in the first 3 years that we can't tell that with this test. So if someone is prescribed a benzodiazepine or an opioid or an amphetamine, the oral swab will tell you that it exists, that yes, this person has had a benzo, but we don't know how much. We don't know if they took the right amount, which is the order of the treatment court. So the boilerplate asking us to determine compliance with the requirements set by the treatment court, doing what we've been doing, we cannot meet that request of the legislature. Further, it goes on to say that we have to report, and this is a shall, that the oral fluid prescription compliance oral fluid testing serves the benefit of this state of using oral fluid testing. So we've, in 3 years, showed what benefit there is. However, we don't know whether the oral fluid testing is any better than the more common test, which is a urine drug screen. So what we're hoping to do, as we've accomplished some of the things in Section 404 historically, is to do the rest. You've asked us to do a job, and as I've explained, we have whole groups of people that are just trying to understand what you've asked us to do and trying to go do it. And so these specific lines in Section 404, we cannot do with the method that we used the first 3 years. We believe we've accomplished a lot. We believed if you look at all of 404, there's lots of boxes we've checked. I think importantly, if the goal were simply to make oral fluids available to problem-solving courts, veterans treatment courts, as you suggest, we would just put the money in that line. In fact, today, any problem-solving court certified by the State Court Administrative Office can pay with grant money for oral fluid testing. There's no barrier. They're not required to use something other than oral fluids. It's a valid option. In this regard, I'm quite a bit of a capitalist. We have a capitalist marketplace where people compete for the business of the courts and the probationers to determine how they're going to prove compliance. So as the invisible hand of this capitalist marketplace, we think you've asked us to make sure that these things both work. So what we're trying to do, and what we've sent out a request for proposal earlier this year, is to hire an independent evaluator to test these two things. Is there a way to determine that we know how much of a specific prescription drug was used, which is what the requirements set by the treatment court pursuant to Section 4. We want to know, is there a way to figure that out? And finally, is there a way to determine the benefit to the state? Meaning, is this a better way to go for whatever reason than a urine drug screen, which is much more common? So, as a judge, as a chief judge, as a judge presiding over a problem-solving court, I would have loved to use oral swabs. They're more convenient. Probation officer takes it out of the drawer, swabs a defendant, drops it in the mail, right? What we do is we did when I was in the district court, asked the probationer to go to the local urine drug screen. At the time, it was a company named Adam, Alcohol Drug Administrative Monitoring. I believe they've been bought out by somebody else, but I haven't been there. So, and you know what? Sometimes they didn't make it. They'd walk out our door and we wouldn't see them for 6 months. So, there's a benefit to it. But we never, exercising our responsibility with state grant dollars and county fund dollars, saw the competitive advantage from a fiscal perspective. So we stayed with urine drug screens. So what we're trying to devise with this request for proposal is to answer the questions that you've asked us. Can we assure compliance with the treatment court order? Can we show that this is a benefit for the state, meaning it's better than its competition? And in the old paradigm, the tests we've done for 3 years, we've fallen short in those. So what we're trying to do is to check these couple last boxes off from Section 404.
So related to that, there's a $500,000 line item in the budget,
Yes, sir.
and it was for the oral, and I guess was it for simply the study, to do the study and the RFP for it, or was it for the finalization, actually the doing of those oral swabs?
Well, I think it's going to have to be both, but we're pretty early in the process to know the answer to that. The RFP suggested that the proposal could be for as much as $200,000, but that doesn't mean the RFP has to be for $200,000. It's a cap, right? And as indicated in the previous question, we've spent none of this money. So all of the work developing the RFP and all that, we've just used, one of the two lines that we're here to talk about today.
Yeah.
And honestly, because without disregarding the lines, without disrespecting the lines, I don't focus on them. So I couldn't tell you which of the staff that have been involved so far come from one of those lines or the other. I think it's fair to say that it's one of the two, and the money that, Mr. Chairman, that you've asked me about. But we are dedicated to doing this and doing it right. So the money that we've spent to develop the RFP, to submit the RFP, to follow up on the RFP, none of it's come from the $500,000.
Should be
So you're just gonna put that money back in the general fund? We really could use it for roads. I'm just asking.
No, it's a great question. We're still committed to getting this done, and we believe we're gonna. I think that what we're gonna do next is republish the RFP. We've taken steps. We submitted the RFP and nobody bid. Nobody submitted a proposal, which is unfortunate because we think it's interesting science, and we think if we could prove, that oral fluids are better than urine drug screens and why, perhaps we could create a capitalist market where they became cheaper because of economies of scale. I don't know, right? But if there's a benefit to the state pursuant to Section 404, we'd love to know it. And so if we can do the test, we still want to do the test. But absolutely, if the test fails, we will not spend the money, and we will lapse it back to the general fund. Absolutely.
Mr. Cabot.
Thank you, Mr. Chair. Could you give us a quick update on the work projects for case management? I believe there was $150 million that was allocated. How many courts are actually on the system? How much money's been spent? Is there an anticipated finish date? And are you needing more money for that system? Is that what I'm hearing?
Oh, definitely not that last part.
Okay.
Some of the others, what I'm going to do, Mr. Representative, Mr. Cavett, with the chair's indulgence, is I'm going to answer what I know, but we're going to get you a written answer in detail within the next couple weeks. And I say a couple weeks because my right-hand man over here, Mr. Harold's going on vacation, so I got to let that happen. So within the next couple weeks. So the $150 million one-time appropriation is to migrate courts that are not using GIS onto GIS, so we have a statewide unified case management system. We have indentured, obligated, I think it's 85, or is it 65? It's one or the other. We have obligated 85 million of that and have 65 million not yet obligated. And when I say obligated, I mean that's either spent or in contracts, meaning we've committed to spend it on different projects. The number of courts that are currently on GIS, ballpark, Representative, because again, that was not one of the questions I had prepared for, but it's roughly 200 of 250 individual units. So like some courts have 2 locations. Ottawa District Court has 2 locations. Van Buren Circuit has 2 locations. So we count those as individual separate places because we have to have a separate installation. So something like 50 are already on JIS. JIS handles something like 80% of the caseload already. And so when in partnership with the legislature, we received that appropriation, our first question was, what is the responsible path forward? We cannot assume that we know that. So we retained the National Center for State Courts to come in and independently review, the system, the incumbent system, JIS, and they're familiar with many national vendors that are out there that could have come in and replaced JIS, as other states have done. And their response was that no, JIS was the logical way to go forward, and it was a sound investment to build upon. And so where we are is we've obligated a little more than half of the money. We're making great progress. As I've said, our number one project today, we have lots of little projects, but our number one project today is the migration of Oakland Circuit onto the JIS system. It's our largest court today is Genesee Circuit. And so Oakland Circuit is 2 times larger, 2.5 times larger, whatever the number is. And so one of the things that the larger courts are concerned about is JIS scalable, right? We believe it is, our experts believe it is, experts hired by Oakland County believe it is, but we have to prove it. And so Oakland County is real important because we will prove scalability. And we can get you more information about that, but that's what I know off the top of my head.
Okay. So just for clear, you're not asking for any money in this budget for this program at all?
So there is money in this budget, not to augment the one-time migration money, but as we represented to your predecessors when we initially asked for the 150, as you create a bigger system, you need to spend more to operate it on a daily basis. So our original request to the executive and legislative branches were $150 million one-time money to migrate the courts over to JIS, and $38 million in non-one-time money, recurring appropriations to facilitate a bigger system. So Representative Cabot, the analogy would be if you build a wing onto your hospital, you've added capacity to your hospital, you did that with a bond, you did that with a one-time payment, but now you've got a bigger hospital, so you need more beds and more nurses and more doctors. That's where we are. So as we build on more capacity, we need more customer service. We need more computer analysts. We need more security specialists. So our original request was 150 one time and then 38 ongoing. Very appropriately, the legislature, the executive branch said, well, how much do you need today? Because you can't flip a switch and take everybody in, so we've been growing slowly. And so the request is for the legislature this year, which is an additional $7.2 million is the next slice of that growth. Last year, we asked for a certain amount, and $1.7 million of that was diverted to a different purpose. So we're trying to catch up to make sure we have the ongoing resources to function the larger system.
How do you calculate those numbers when the build-out isn't complete?
Well, we know what we've added. We know what we've added in terms of the courts that have come on. So, for instance, we've added Ottawa Circuit, which is a top 15 county. We're almost done adding Ingham Circuit, and then we have lots and lots of probates and districts that we've added. Again, we can get you a report of the status of all of that.
Okay, thank you very much.
So I've got a couple questions that I think might help us get to the end of having you in the hot seat. How's that?
It's been my pleasure, Mr. Chairman.
So my one question is, how do we encourage the counties, the various courts to get on board with the JIS system? So that, because I think sometimes we either need to incentivize or it's the carrot or stick thought process, right? So sometimes we need to help people decide that they could move towards something that we're trying to help them get to. Is there a way that we can do that?
You in fact have, by elimination of the JIS user fee. Okay. So the legislature has played a part in that process, and it was a pivotal part. Because if we have a jurisdiction that the judges really like the screen being blue instead of green, or the button over here instead of over there, that might stall migration. That sort of personal preference might become an obstacle. But when you say to the county commission that funds that court, you can keep paying the bill or we're going to pay it for you, the conversation's pretty short. And so honestly, at this point, we have more people wanting to come to the system than we have capacity to bring on today.
Second question is, you've said to your partner over here, Mr. Harrell, that he's going to be responsible for responding back to us related to the dollars and by functional units, maybe even in your org chart or however you're going to do that. When should we expect that?
So again, it's only because of a vacation that
I get it.
everybody needs to have. I'd say 2 weeks from today, if that's okay with you. And what our plan will be to do is, and again, it could be last fiscal year, it could be the first 2 quarters of this fiscal year, it could be both, whatever your preference is, Mr. Chairman. You could have Ms. Risco let us know, we'll get it for you. The easiest thing for us to do and the quickest will be to just use the Sigma units because that's an accounting system that already exists. I mean, it's great. It's an independent, co-equal branch of government, the judiciary, but we rely on the Department of Technology Management budget for a whole bunch of things, including the payment system, Sigma.
Awesome. Looks like we've answered all the questions for the moment.
Yeah, it's a great pleasure. And again, we cannot do this without the partnership of the legislative branch. Thank you all very much.
Thank you. Thanks for being here, all of you. And with that, I think we've all have answered all the questions, or asked all the questions at least we needed to ask today. And with that, this meeting is adjourned.